Good afternoon, good evening, good morning, wherever you are. This is Dr. Olu Asekun. Welcome to our live podcast. Thank you for joining. And please remember to invite your friends, your family, your colleagues to join us as we journey together in this immigration current administration's policy. Welcome again to this podcast. We do it every Wednesday, Central Standard Time. That is currently 12 p.m. Central Standard Time, 1 p.m. Eastern, 10 a.m. Pacific, 11 a.m. Mountain Time, and I believe currently 6 p.m. Nigerian time. So, wherever you are, good morning, good afternoon, good evening. Welcome to our live podcast. Today, we are still continuing with the immigration update under the new administration. Do you remember what part we are right now? This is probably part 9 or 10. Okay, this is part 10. Like I said before, right now we are still going to be going through the update until everything subside, then we go back to our normal way of doing our podcast, which is by topic. But for now, we are still going to continue the updates and general questions because it is a desperate situation requires a desperate solution. We are currently in a desperate situation, and it is important that we apply a desperate solution. So that is why we are doing this on a. Huh? Oh, this is part 11. Oh, okay. Yeah. Immigration update under the new administration, part 11. This is our part 11. So, as I said, the current situation requires that we provide updates on a weekly basis and also answer questions so as to help as many people as possible. Today, we are going to start with the update of new developments between last week and this week. And we are also going to give out some warnings to people, to our listeners, and then we'll go into questions and answers. Now, between, can you please mute it? Between last week and now, as I always say, when a masquerade is pursuing someone, as the person is getting tired, the masquerade will also get tired. The number of executive orders and policies are reducing. However, the implementation of the existing policies have not reduced. In fact, they are becoming more and more difficult. The implementation of the executive orders that has been signed, they are not increasing. But what is decreasing right now is the new policies. At least I can tell you between last Wednesday when we did the last policy and today, the president has not signed any new executive order that affects immigration. However, there are some policies that are actually being implemented that are affecting immigration. For example, this week, the Department of State have revoked student visa for a lot of students who are in the United States. They have revoked student visa for a lot of students who are in the United States. Now, I want to say this. If you are a student in this country, I've said it before and I'm going to repeat it. please do not participate in any protest. Leave protest for US citizens. We all know that, yes, America, there is freedom, there is this, there is that. But under the current administration, they believe that those freedom does not extend to non-US citizens. So if you are on a student status, or you are even on any status that is not yet a US citizen, please do not participate in any protest. Again, be careful what you post online. The DHS, the Department of Homeland Security, they are currently scanning online, looking for people who are anti-government, anti-US government, looking for posts that have been, for something that has been posted that they consider anti-government. Somebody asked me, I don't know whether it was last week or this week, that do they have the right to seize the phone of a US citizen at the border? Yes, they do. At least the court have said that they do have that right. I have a friend who is also a lawyer here in the US who was coming into the US from Canada, and they collected his phone at the airport. Not only did they look at the content, but they also downloaded it because they copied it. They copied the content of the phone before returning to him. He was not accused of any offense. He was not charged for anything. They didn't even tell him why they had to search his phone. So when he told me about it, we decided to file a lawsuit to challenge DHS. That this is an American. Why would you do that? You do not have the right to do that. But guess what? The court said that they do have the right to look into the phones of people coming into the US, whether you are a citizen or not. Because according to the court, how are they going to determine who is a terrorist and who is not? And it is possible for a US citizen to also be a terrorist. That was their argument. We filed an appeal in the case. Again, the appeal court said the government have the right to do it, even to a US citizen at the border. Only at the border, not in the country, only at the border. There is a big distinction between the power of the government at the border versus the power of the government inside the US. Inside the US, a warrant is required before they can search your phone. A warrant is required before they can even get into your house. But at the border, the court have said that they can check your phone, they can check your luggage without warrant at the border. That is what the court said, even to a US citizen. So, yes?
But I know also as a US citizen, you have the right to say no. And they cannot force you to, as a US citizen, only
That is in the country, not at the border.
at the border.
Well, there's a case. That was what I believed. That was why we went to court. But the
But
court
did they say no?
the court said that the government have the right to check the phone, to even copy the phone at the border, not in the country, but at the border. I mean, that was my belief too before the case, that they cannot do that. It was the Fifth Circuit Court of Appeal. It was the Fifth Circuit Court of Appeal. So the point I'm making is there is a big distinction between what the government can do to a US citizen at the border versus inside the US. Inside the US, they are required to obtain a warrant before they can do anything. All of your rights are protected. But the court have said that at the border, the government can check your phone, check your luggage, check everything without a warrant at the border, not in the US. At the border when you are entering the US. So the court has made that very clear. Like I said, this is a case I was involved with, so I'm not speculating. I'm not telling you what I think. I'm telling you the reality. The court have said that the government have that power to do it. So if they can do it to a US citizen, how much more those who are not US citizens? Please do not get involved in anything at all that criticize the current government. Even if you are going to claim your right, a lot of things will have been destroyed before you have the chance to claim that right. And I tell you, if you are not a US citizen, that claiming that right may be a Herculean task. So that is my warning for today. Like I said, so many visas, so many student visas have been revoked for students in this country, either for participating in a form of protest or for posting something online that the government considered antagonistic. And the secretary of the secretary to the Department of State, Senator Marco Rubio, actually defended it on CNN that visa is a privilege, it's not a right. And of course, anything that is a privilege can be taken away without any recourse. So I want my listeners to understand that. Why is this thing going down today? So I want my listeners to understand that, and please avoid anything that can lead to the revocation of your status if you are not a US citizen. Be careful of what you post online. Secondly, the Department of State, they have also announced that they are going to restrict visas to people that they consider are helping illegal aliens to enter the US. I don't know what criteria they are going to use to determine that. But if they believe that you are helping illegal people to enter the US illegally, you will be denied visa. Again, what criteria are they going to use to determine who is helping illegal? I don't know. But these are the things that are going on. So today, I believe we have a lot of time and we will go into questions. But one more thing, because we have had report of US citizens who are wrongfully or mistakenly arrested along non-citizen. If you are a US citizen and you are arrested, contact civil rights attorneys. I mean, as a US citizen, you have a right, and if they mistakenly arrest you, you should make them pay for it. So just contact civil rights attorneys. They will be able to help you. So today we are going into questions. Let's start from those that we didn't answer last week, please. Okay. The very first question from last week. A friend's husband has a pending asylum case and his F1 wife was added. She also has a pending EB2 petition and plans to stop school once she gets an asylum-based EAD. So what's the question?
I don't see any question.
Okay, go to the next one. There's no question on this one. Good day, sir. Thanks for all you do, sir. I'm asking this question on behalf of my friend. She got denied based on marriage fraud 204C. She is on VAWA. Is it safe for her to travel on parole document? No, it is not safe for her because of if immigration already made a 204C determination, the VAWA is probably not going to be approved. So if she travel out of the country and they deny the VAWA before she return, she may not be admitted back into the US. So because of if they already made a 204C determination, VAWA would be difficult to get. So traveling is extremely risky. The next question, please. Does the asylum EAD affect or cancel her EB2 petition? Can she apply for another employment-based petition while asylum is pending? Well, in order to answer this, I will need more information. I don't know at what stage was the asylum filed. Was it filed while the I-94 was still pending? It is one thing to file asylum within 1 year of entry, but it is another thing to file it before the expiration of the I-94. So the answer depends on a lot of factors that I don't have the answer to. I don't have the enough facts to be able to answer this specifically, but on the face of it, if the asylum application was filed while the I-94 was current, yes, she may be able to adjust through another employment-based petition while asylum is pending. But if the asylum was filed while the I-94 has already expired, no, she will not be eligible for any employment-based petition. But let me say this. If I were this person, if you are on F1 and you are maintaining legal status, I will not change from F1 until the adjudication of the asylum, because at the end of the day, if the asylum is denied, both of you are going to be in jeopardy. The next question, please. Good day, sir. Many thanks for the good work. Can a K3 visa applicant be eligible for waiver of alien smuggling? What kind of question is this? I don't even understand it. What is waiver of alien smuggling? I mean, there's nothing like waiver of alien smuggling.
Maybe they were accused.
Are they talking about a T visa?
Trafficking.
That is trafficking, but that's a criminal offense. So if you are accused of trafficking, there's no waiver for that. That's a criminal offense. There's no waiver for that. Anyone who is accused of trafficking, there is no waiver for that. The next question. How easy is student visa under this administration? I'm trying to use this avenue for my sons to do PhD, waiting for change of status for 4 months. Nothing is moving. Is it the same? It seems the two questions are not the same.
No, this is another person.
Okay. How easy is student visa under this administration? I'm trying to use this avenue for my sons, but I don't know if this person. No, don't move the other one.
I wasn't sure if there was a part two, but
Okay. Yeah, I'm trying to use this avenue for my sons to do PhD. Well, I don't know if your son is in the US or outside the US, but generally, student visas are discretionary. It's not something that is guaranteed. It is discretionary. I've seen people who have paid school fees and they were still denied visa. And I've also seen people who have not even paid anything and they were granted visa. Every non-immigrant visas, including student, is 100% discretionary. So, but there is no harm in trying for as long as there is no false information in the application. There's no harm in trying. Okay. No, where is that next one? The one that started with waiting.
we're going with last week's questions first.
Is that a question for this week? There's a question that I saw. This one. Is it this week?
This is from this week.
Okay. Let's see any other one from last week. Okay. We attended the first interview and did make it because we didn't file tax together. They invited us and later called us to hold on. Please move forward. Can I upload the new tax while we wait for second interview? Oh yes, if you have any additional evidence and you have registered for online account, yes, you can upload any additional document you have. You can do that. Next question. You jump one too. Is that for this week? Okay. Hello, sir. Can a person on F1 visa who is married to a person with asylum pending case switch status to asylum dependent to get EAD and stop schooling? I thought I answered this question multiple times. Well, you can do it, but you put yourself at risk because if the asylum ended up being denied, you are going to be in removal proceedings. So if I were you, I will stick to the student status, maintain legal status until I'm able to get something out of it. I mean, I'm sure if you finish your program and graduate, you can apply for OPT at the end of your program and be able to get employment authorization. But if you switch to asylum, you are putting your egg in one basket. So your option will be limited to the asylum, and if it is denied, there may be a problem. So you have to consider all of that before you take a final decision.
That's part two right there.
Part two, okay. Also, will this affect a pending EB2 NIW? Well, pending EB2 NIW is only a petition. It is not adjustment. Remember, EB2 is affected by visa bulletin. It is affected by current priority. So EB2 is not current right now. And for every employment base, you have to be maintaining legal status at the time of adjustment or application. This is one of the reasons why I said that if I were you, I will stick to my student status and get the EB2 and wait for the outcome of the EB2. If the EB2 is approved, then you know that is a matter of time. Apply for OPT, keep yourself in status until whenever visa becomes available. So that way, you don't risk it. But if you switch to asylum, yes, that may be fine. But if the asylum is not approved, you may have some challenges. That's the next one. Good afternoon, sir. I will be going for my asylum hearing later in the year. Can I change my status to EB2? I filed my asylum 9 months after I got into the US. My answer is going to be no, because if you file your asylum 9 months after you enter into the US, there is a chance that you have been out of status at the time you file your asylum, because I've never heard of anybody being granted 9 months I-94 except if you are on student visa. Please move on.
So we start now from the ones that were posted today.
Okay, so how are you going to identify the one we have answered before?
I put last week.
Okay, thank you. Questions from today. Good day, sir. Can my 20-year-old daughter, who is still on my pending immigration court hearing, get married? And what will her status change to if that happens? Well, if he's married to a U.S. citizen, the U.S. citizen can file I-130 petition on her behalf, and then she can apply for adjustment of status. However, let me say this. If this is what you are planning, time is of essence. I can tell you the experience right now under this current administration, the experience is that immigration judges are reluctant, very reluctant, to grant continuance, especially if DHS is opposed to it. If DHS is opposed to continuance, they are very, very reluctant. So if you're already in removal proceedings, time is of essence. So if that is what your daughter is planning to do, the earlier the better. Next question, please. Hello, sir. Thank you for all you are doing here. Thank you. We appreciate it too. The next question or comment. Okay, this is a question. Good afternoon, doctor. Thank you for all you do, sir. A friend of mine was denied based on marriage. I already answered this. The one that wanted to travel on vow, I already answered this. That's why I was asking you how you're going to identify.
They posted it again
Okay, okay,
from last week and this week.
okay.
Someone says
Hi, doctor. Hello to the next question. My asylum was approved on the 13th of March 2025. What should I do next? And hope to hold on to the green card and hope the hold on the green card will not affect me by the time I wanted to apply for my green card. There is no hold on the green card because asylum allocation is different from employment-based other employment-based allocation. So for as long as there are no approved petitions that are more than the number available, there is no hold. If your asylum was granted on 13th of March, you will be eligible to apply for green card on 13th of March 2026. Next year, March next year, you'll be eligible to apply for green card. So there is no hold on the green card. Congratulations on being granted the asylum. The next question. Good afternoon, sir. Thank you for your time. Thank you too. The next question. As an American citizen that has a newborn in Nigeria through a surrogate mother, what is the process of bringing my new baby to the state? How do I start the process and how long will it take? Sir? Well, this is a very, very technical question, and I wish you had asked this question before you embark on this process. Surrogacy is extremely complex. Surrogacy is extremely complex. Whether you'll be able to bring this child or not depends on the surrogacy agreement that you sign. It depends on a number of factors because you are not going to be able to prove that you are the biological father or biological mother of this child, and the unfortunately the law did not specifically address surrogacy. The law does not specifically address it. It's a complex situation that you have put yourself into. You should have found out about this before embarking on the journey. It may be difficult, if not impossible, for you to bring this child to the US. The next question, please. Hi, Dr. Asekun. God bless you for everything you do. You and your team are doing. May God continue to bless you all. Amen. Thank you. Next one, please. I got a request for initial evidence on I-765, and after mailing the evidence and it shows delivered after I track it but no changes after 7 days in my USCIS portal, can I respond online as well? If you have a portal, you should have just posted the request for evidence instead of mailing it. But yes, you can do that. But sometimes the fact that they have not updated it does not mean they have not received it. Excuse me. So if you have evidence of delivery, that means they have received it. So there's really nothing to worry about. 7 days is not a whole lot. Please, next question. Okay, I answered that. Waiting for change of status for 4 months, nothing is moving. Well, I hope this person is not referring to adjustment of status, but if it is change of status, what I want to say, what is your current status? If your current status is B1, B2, I'm going to advise you to submit an application for extension of your current status. Because if we recall, during President Trump's first term, when people apply for a change of status and their current status expires, the change of status application they were being denied at the time on the ground that they were already out of status. So at the time, during his first term, what we did was to encourage people to continue to apply for extension of their B1, B2 status while waiting for the adjudication of their change of status. So what I'm going to advise you, if you check the kind of application you file, whether it is eligible for premium processing, If it is eligible for premium processing and you can afford it, go ahead and apply under premium processing. File Form I-907 to request expedited processing. To the best of my knowledge, most change of status actually allow premium processing. H-1B allows it, R1 allows it, even student visa allows expedited processing. So if you think time is against you, just pay for expedited processing by completing Form I-907. I-907, and then you pay the fee for your category, because the fee is not the same. It depends on category by category. So you look at the category of the change of status you filed and then apply for I-907 in that category. Next question, please. Thanks for all you do. I filed an I-130 for a relative, brother and his family in 2016. Last August, the petition has been migrated to Ellis for processing. How it takes to process, maybe how long does it take to process from this point? Well, one thing I will tell you, is that a part two?
Yes. There.
Okay. The children are no longer minors. Are they still eligible under the I-130 petition filed?
Yes, that's it.
Okay. First and foremost, for children that are 21 and above, they are not eligible. They are not covered by the petition. But if they are under 21, at the time that your brother or your sister will be able to apply for adjustment, then they will be covered. But secondly, and most importantly, petition for siblings, they are not given priority. And if I recollect, I think we checked last week or so regarding the current priority date for siblings is about 16 years waiting. And if your application was submitted in 2016, you are not even close, because that is still less than 10 years. So you are not close. You still have a lot of years to wait. You still have a lot of years to wait. So there's nothing you can do at this stage. The next question. Can I upload the new tax? No, I already answered that. Yeah. You can upload it.
No. Florio.
Okay. The next question. Is it safe to travel to Nigeria with advanced parole, adjustment of status pending for EB4 religious worker? Oh yes, for as long as you are working for the employer. Because for religious workers, there is one challenge for them, and the challenge is the word solely. 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 If the law requires that you must be working solely for the employer, for the religious organization. So what that means is that you are not permitted to work for multiple employees. You are only permitted to work for the petitioning employer in a religious capacity. So if you work outside of the religious organization, that may be problematic when you are returning. But for as long as you are complying with that, yes, you can travel. You can travel. But if you are not working for the religious organization, if you are doing a secular job, I will not travel until I get the green card if I were in your shoes. Because when you are coming back, CBP officer may decide to do secondary inspection. And when they do that, they pull a lot of information about you, including your finances and your employment history. Remember, with your social security number, they have access to all this information. Every time you get paid, the Medicare tax, the social security tax, the IRS tax, all these deductions go to the government record. So the CBP officer can pull a lot of information about you. They can access a lot of information. So if you have been working outside the church or outside the religious organization that petition for you, I will not travel if I were you until I get the physical green card. But it's a risk that you have to consider before traveling. The next question, please. Dr. Asekun, is there a downside to a U.S. citizen sibling petitioning for someone who is currently out of status? Will it automatically be denied? No, I don't understand the question. Is this for a U.S. citizen to petition for somebody or a U.S. citizen sibling? I don't understand what
A
it,
U.S. citizen petitioning for
it says
a
U.S.
sibling.
citizen sibling.
Yes. So it's a sibling petition. A U.S. citizen sibling or person filing for a citizen, for a sibling, sorry, who is currently out of status.
The question is not clear, but let me answer
There
it,
is a part two.
assuming the what you just explained is
There's a part two.
okay. There's a part. Okay, can it affect other relief the person can seek in the future? But I'm trying to determine who is the petitioner, who is petitioning, because it says U.S. citizen sibling. Is the U.S. citizen petitioning for the sibling, or is the U.S. citizen asking this question on behalf of a sibling who is also a citizen?
I see the first part.
So it is a really complicated question. But let me answer it both ways. A US citizen can petition for somebody who is out of status for as long as the person entered the US legally. That is it. But talking about sibling petition, a US citizen cannot petition for a sibling who is out of status, because the exception for people who are out of status is to a family of a US citizen. The exception is for family of a US citizen. And the way immigration law defines family, siblings will not qualify as family. Siblings are considered extended family. Next question, please. Sir, how can someone correct his or her inconsistency in declaration statement during the interview at USCIS with adjustment of status at the immigration court hearing? Well, inconsistent in declaration statement during the interview. So what kind of petition is this? Because I'm trying to understand it. Is this talking about adjustment? But he's talking about adjustment, and the question also seems to be like a asylum question, because it is only asylum question that you have declaration statement,
Maybe
but you
means
also don't
asylum
have.
office.
Oh, okay,
Adjustment of
maybe
status.
maybe asylum office. Okay, let me read it that way. How can someone correct his or her inconsistency in declaration statement during the interview at the USCIS with asylum office or with asylum officer at the immigration court hearing? Well, what we need to do is to file a brand new application for asylum at the immigration court and make sure that all the adjustment is made, correct all the errors. However, during hearing, the government lawyers may attempt to show to the court that you are not consistent by bringing out what you did before. Well, depending on who is your lawyer, I always object to it on the ground that asylum officers' notes are not part of the proceedings in court. So it also depends on the gravity of the statement that is not consistent. If it goes to the root of the claim, definitely there's no way the judge will unhear what he has had, because the government lawyer is probably going to bring it out. That is what they are trained to do. That is their job, because they will want to convince the judge to deny it. So it is also your lawyer's duty to try to convince the judge why you should not deny, why the statement should not be considered. But there is a lot of things that I don't know about this particular case, because number one, I don't know the gravity of what the statement is. I don't know whether when you make this statement at the asylum office, whether you are represented by a lawyer or you only represented yourself. whether the application that was submitted to the asylum office, whether it was signed by a preparer. If it was signed by a preparer, you can also, another defense you can have is to tell the court that, look, you didn't prepare this one yourself, you used a preparer, and you did not understand that that was what they put in there. You only got to know about it during the interview at the immigration hearing, and that is why you want to set at the asylum office, and that is why you want to set the record straight. So there are different ways you can do it, but the best way to address it, submit a brand new application to the immigration court and let your lawyer argue that the previous information provided to the asylum officer should not be admitted in court, because asylum officers' notes are not part of immigration proceedings. They are their personal opinion, which is biased. So it is the duty of your lawyer to object to the admissibility of that evidence during trial. Next question, please. Please, sir, is there any issue of someone was denied N400, did biometrics during the process and later filed from I-336 and still asked to go for another biometrics? Keep going. Is it safe to go? Oh yes, N400 is citizenship application. You can go. Application Support Center is where they do biometrics. Let me say this again. The office where biometrics is done is not an immigration office. It is called Application Support Center. They don't detain people, they don't arrest people there. The only thing they do is they take your fingerprinting, they take your picture. That is what they do. If you notice, a lot of application supporters, a lot of application support centers, they are located inside malls, inside shops. They are not immigration office. So they don't arrest people there. So they only do their job. They take your fingerprinting and your picture. Yes, you should go. The next question. Please, what is the update regarding the filing of taxes for undocumented? Very, very good and complex question. To be honest with you, at this time, I don't know how to advise you on this one, because on one hand, the law requires everyone making money in the US to file taxes, whether you have Social Security or not. On the other hand, the Trump administration is negotiating with IRS to use tax ID of people to be able to identify those who don't have status in the US. So far, as of today, there is no update. We don't know whether the IRS is going to cooperate or not. But the last thing we heard about it is that they are negotiating. I don't know if the IRS is going to agree or not. But to be honest with you, if the government is insistent, it's probably going to be difficult for IRS to say no. Because if they do, they can fire whoever is the head of IRS. But right now, they are still negotiating. We don't know. Maybe something maybe reasoning will prevail on this government and they will not do it. But for now, we don't know. There's no update yet. They are still negotiating. Next question. The next question. I got my green card in February 28. It's marriage-based. Married since 2022. When can I apply for citizenship? What's the current processing time for citizenship application in California? Well, I don't know. I'm assuming that this person is talking about February 28th of this year. Or Marisa, do you get my question? Is there any follow-up or anything? Is this referring to February 28th of this year? Well, if it is not clear, I'm going to answer it multiple ways. Number one, if you are talking about February...
No, I think she's talking about, she's confused about the marriage date and the marriage when she got the green card.
Yeah, but I'm talking of the date of the green card. Is it
Yes.
February 28th of 2025?
I think so.
Okay. If it is, if you got your green card in February 28th of 2025, if you are still married to your US citizen spouse, you will be eligible to apply for green card 3 years from that February 28th, 2025. So 3 years will be 26, 27, 28. February 28th will be 3 years. February 2028 will be 3 years. However, you can apply 90 days before. So if you take 90 days from February 2028, that will take you back to November 2027. So you'll be eligible to apply for citizenship in November 2027. Let me tell you, for the purpose of citizenship, they don't look at the date of your marriage. They look at the date of your green card. The date you obtain your green card, you count the 3 years from that date, not the date of your marriage. Secondly, if you want to become a citizen much earlier, it doesn't matter which state where you live. If you want to become a citizen much earlier, you can join the US military. If you join the US military as a permanent resident, then your citizenship will be very, very fast. You may even become a citizen before the end of this year. And like I said, it doesn't matter what state you are applying for, whether you are in California, Texas, New York, New Jersey, Colorado, it doesn't matter. The next question, my wife is a US citizen.
He's just giving you more information about his question.
Okay, it's the same person. Yeah, I already answered. If it is based on the marriage to the wife, your citizenship will be 3 years from the date of the green card, not the date of marriage. The next question, a friend went out of status last year. Can they get married to their US girlfriend? File a family-based petition and upon approval, file for EB2 as against getting his residency through his marriage. No, you cannot do that. If he's already out of status, he's not eligible for green card based on employment or based on EB2. But if he's married to a US citizen, yes, he can get his green card through the US citizen. But he cannot go back to apply for green card through EB2. No, it doesn't work like that. Next question, please.
Okay, so the person that you just answered the previous question, he's just sent this one. This one right here.
Okay, what if I divorce now? Will that impact me in the future? I have 10-year permanent resident. Yes, it will impact you in two ways. Number one, you will no longer be eligible for citizenship in 3 years. You will have to wait for 5 years. That is one. Then two, whenever you apply for citizenship, they always go back to look at the marriage, the good faith intent of your marriage. So if you got green card in February and then you file for divorce in April, of course, there is nothing immigration can do about your green card, but when it is time for citizenship, they can ask questions. It doesn't mean they will deny it, but they will ask questions. How come as soon as you obtain your green card, you file for divorce? What happened? They can ask that question, but it doesn't mean they will deny it. But definitely, it will affect your ability to apply for citizenship in 3 years. You will now have to wait for 5 years. However, if you decide to join the military, it will not matter whether you are divorced or you are single. You will still, your citizenship will still be faster because in that situation, it is going to be based on your service to the United States, not on your marriage. The next question. Okay. Good afternoon, sir. Thank you for your support. Please, sir, can anyone apply for citizenship by yourself online? I have used a total of 5 years from my permanent resident. Or is it advisable? Is that a follow-up? Is it advisable or is that where I stopped? What's the follow-up?
maybe he posted two different questions. This is one,
Yeah, it's the same thing.
and this is the other one.
Good days are on can a person apply for citizenship by himself? He has spent in total of 5 years from his 10-year permanent residence. Oh yes, you can apply for citizenship. You can file any application for yourself for as long as there are no complications. Yes, you can apply for citizenship by yourself. The only thing is, I always tell people, he who lives in a glass house does not throw stone. If you know that your case is not straightforward, it is always better to have a lawyer represent you, because when you go inside that office with the officer for interview, if you are by yourself, there are certain things you may not know how to handle. If a lawyer is there with you, even if the lawyer didn't say anything or didn't do anything, the fact that the lawyer is present will call the officer to order. The officer will not do things that are not proper. The officer will not intimidate you. The officer will not there are certain level of protection. But again, if your case is straightforward, I mean, there are a lot of straightforward cases. You got your green card, you don't have any criminal record. If you got it through marriage, you remain married to your spouse, you are living together, there is no issue. Yes, you can do it yourself. You can apply for yourself as long as you don't have any complications. But if you know that certain things might bring up complications, it is better to have an attorney. Sometimes a lot of people do what we call penny wise, pounds foolish. Sometimes the lawyer may see the trajectory of the interview and decide to step in. But if you don't have a lawyer there, if the trajectory is not going in your favor, by the time you leave that office, a lot of things may have been damaged. For example, I've seen situations where I take clients for citizenship interview. During the interview, I see the trajectory of the questions, and I told the officer, I paused. I told the officer to suspend the interview, and I told the officer that at this point, we want to withdraw our citizenship application. We do not wish to proceed, and I want the case withdrawn. So right there and then, we wrote a letter of withdrawal and we ended the interview. In such a situation, if there is no lawyer there, you may not know that that will be beneficial to you, because before the government can use evidence against you, they need to have the evidence. And in most cases, you are the one that will provide the evidence when you don't have the lawyer. They will be asking you questions, and sometimes they may even ask you to sign a sworn statement. They will ask you questions, they will write the question down, they will type your answer. At the end of the day, they will print it out, they will give it to you to sign, so that they can build all this evidence against you. But if you have a lawyer and the lawyer is already seeing the trajectory of the interview, the lawyer can stop the interview right there. And if the interview is stopped, there are no evidence in the record, they will not be able to use anything against you. But again, if you don't have a lawyer there and they build all this evidence, and then you go out of there and you go now to consult, to hire a lawyer, that would be like crying over a split milk. The lawyer cannot go back there and take out document from your record. The record is already created. So sometimes it is advisable to have a lawyer, but if you have a straightforward case, you honestly don't need a lawyer. The next question, please. Okay. My son is a green card holder schooling abroad and plan to apply for re-entry permit. The process will make him stay back in the US for many months and miss class. Can this be fast track or any option? Well, this person probably don't understand the way re-entry permit work. If your son is schooling abroad and is a permanent resident, all he needs to do while physically present in the US, he needs to apply for travel permit. Not the the permit for permanent resident and the, what is it called? Marisa, can you remind me? What do we call the one for permanent resident? The advanced parole. It's not advanced parole. Is that advanced parole?
For adjustment?
No, no, no. For people who already have green card.
Oh no, it's the
Yeah. So what you need is,
travel document.
yeah, while your son is still physically present in the US, he needs to apply for travel document, giving him for the government advance notice that is going to be staying outside the US for an extended period. He doesn't need to wait for the document to be approved.
Okay.
All he needed to do,
Re-entry permit.
he needed to do was just to apply, file the application. On the date of the application, he must be physically present in the US. That is all that is required. So he doesn't need to wait for it to be approved. He just needed to apply while in the US. I mean, we have done this for clients that spend like 2-3 weeks in the US, because sometimes when you file it, depending on the last time your fingerprinting were taken, sometimes when you file it, they may request your son to appear for fingerprinting. If this happens, if your son has already traveled, you can request that the fingerprinting appointment be rescheduled. Or sometimes you can request that the fingerprinting be taken at the US Embassy where your son is staying. But most importantly, the only thing that is required by law is that on the day that you submitted that application for re-entry permit, your son must be physically present in the US on that day. That is the only thing that is required. So staying back in the US for many months, missing classes, all those things are not relevant. They are not necessary. They are not required. You don't need to wait for it to be approved. You only need to apply for it while present in the US. The next question. Afternoon, sir. Can my 19-year-old college student with enough income sponsor me if most of the income is from summer internship, but not from a part-time job? No permanent job yet. Yeah, your child, the source of the income is immaterial. Well, I don't know the type of application this person is talking about. Is this person a family member, or is it sponsoring somebody who, I mean, I don't know who this person is sponsoring, but the point is, if the person who this person is supposed to sponsor is in the US and is applying for a benefit with USCIS, yes, a 19-year-old college student with enough income can sponsor you. It does not matter the source of the income. It does not matter. However, if this person that is being sponsored is outside the US, no, the college student may not be able to sponsor you. And the reason is simple. For people outside the US, for sponsorship, you need to provide 3 years income, 3 years tax return. But for people applying in the US, you only need 1 year income. So that is the difference. Next question, please.
You already answered that one. Okay,
Next question. Thanks for the good work. I relocated with my family to US few months ago via EB2 NIW. My teenage son is still in the university in England and has 3 more years to complete his status. He can only be coming to the US during holidays like every 6 months to spend few weeks for the next 3 years. We are advised he get re-entry permit. The re-entry process may need him to stay back in US for months, and this will affect his studies. And fast track option or other ways to go about it, please, we need your professional advice. This is probably the same question I answered. Anyway, if it is not, the simple answer is this. While your son is physically present in the US, let him apply for re-entry permit. That's it. If they require him to do fingerprinting, he should wait to do the fingerprinting and then leave back to England. There is no requirement that he must wait for the re-entry permit to be approved. You only need to apply. That is the law. The next question. Hello, my two children and I are US citizens. Can I support someone with IA64 if I'm earning about 32,000 a year? Thank you. Unfortunately, this is not a question that I can answer because determining who is eligible to sponsor is not based on income alone. It is not based on income alone. It is based on a number of factors. Number one, you have to look at your tax return. In the tax return, there is a column that is known as adjusted gross income. Adjusted gross income. So that is what will determine your annual income, and the number of people you claim on your tax return will also affect your eligibility to sponsor. So sponsorship is not by figure. It's not by somebody earning $32,000 a year may be able to sponsor another person, while somebody earning 50,000 may not be able to sponsor that same person. So it is more complicated than that. So in order for us to determine whether somebody is able to sponsor or not, we will need to see the tax return. We look at the adjustment gross income. We look at how many people this person claim in their tax return. You may be making $100,000 a year and not be eligible to sponsor somebody. I've seen people who make six figures and then they also have business. In their business, they declare a lot of losses. So at the end of the day, their adjustment gross income is under $20,000. They may not be able to sponsor somebody, despite the fact that they make over $100,000. Somebody who is making $25,000, who does not have any dependent on his tax return, may be able to sponsor the same person that the 100,000 earner may not be able to sponsor. So it's not that straightforward. So you have to look at what is the adjusted gross income. How many people did this person claim on his or her tax return? Has this person sponsor another person in the past? So there are a lot of information in order to determine whether you'll be able to sponsor someone or not. Next question, please. Good noon, Dr. Olu. You are shining star of our time. May the Lord strengthen you more. Amen. I've used 24 months out of the 48 months granted my I-797, but still now no update from USCIS.
I'm thinking I-751.
Yeah, I suspect it too. Any follow-up? What's the question? I've not seen any question yet.
She wants to know if it's still okay. I mean,
Yeah, what I will advise is to check the processing time. Go online, go to the USCIS case status, and you will see a button there that says processing time. Click on that button. So look at the category of your petition. If this application is referring to removal of condition, you will select I-751. So if it is any other type of petition, look at the category in the draw box, then the draw down, then select it. It will tell you what the processing time is. But if you are given 48 months and you have only spent 4 months, there's really not much you can do. Just keep on waiting. But if it may also be for somebody with a pending, generally 751 is the one that is given 48 months. It may also be 86 removal of condition for investors. I-829, it may be I-829. It may also be, whatever it is, just look at the category in the drawdown. Once you click on the button that says case status or case processing time, you will see how long the processing time is. If the processing time is still within the 48 months, there is really not much you can do other than to wait. But if the processing time has passed, then you can do a service request. Unfortunately, as we said last week, the Office of the Ombudsman, which is another resource that we use. That office has been shut down by this administration and all the employees have been sacked. So right now, if your case is delayed, you can only do a service request, or you go through a congressman, or you file a mandamus if it is eligible for mandamus. The next question, please. I've had a pending asylum case with valid work permit for the past 7 years. I just recently married a US citizen. How do you advise I change my status? Well, if your case is still pending and you have not been referred to the immigration court, then let your US citizen spouse file a petition on your behalf and you can apply for adjustment along with it. So what you need to do, you file form, your petitioner, your US citizen spouse will file form I-130 on your behalf. You will file form I-485. If you don't have a current employment authorization, you can add I-765. But if you have a current employment authorization, you don't need to. And because you already filed asylum, I will not even advise you to apply for travel permit. So just file only those two things, I-130 and I-485. So once you submit it to USCIS, and then when it is time for interview, you go for interview, you tell them that you want to withdraw your asylum application, then that will be the end of the asylum application and they will go into your adjustment of status. On the other hand, if you are already in court, then this process will not work, because the moment you are in court, USCIS will not have jurisdiction over your adjustment application. So the only thing you will be able to do in that case is for your US citizen spouse to file I-130 petition on your behalf, and you have to wait until that petition is approved. So whenever the petition is approved, then you can now file I-485 and apply for adjustment of status in court. Next question, please. Good day, sir. Thank you for your support. I came here visiting the US from Nigeria. I do not intend to go back. Please, how do I transfer my visa to another class of visa? I'm considering. Okay. Okay, I'm considering F1 visa student. Will this be possible, sir? Well, I don't know how long you are given at the port of entry, but assuming you are given 6 months, I don't know how long you have been here. Did he stay can you please go back? Did he stay how long he has been here? I came here visiting. Yeah, I don't know. I don't know how long you have been here, because if you just came in and they gave you 6 months, if you try to apply for student status, that will show that when you are entering, you lied to the CBP officer that you are coming to visit. So that will not show good intent. That may lead to misrepresentation, and your change of status application can be denied on that ground. On the other hand, if you have been here for about 3 months, yes, if you want to change to student status, you can start the process. Apply for admission in school, apply for I-20. Make sure you do all this before the expiration of your 6 months. If your 6 months is getting close and you have not obtained the I-20, even if you have obtained the I-20, apply for an extension of your B1, B2. File in from I-120, I-539, from I-539 to apply for an extension of your B1, B2. Then as soon as you get your I-20, apply for a change of status from B1, B2 to F1. There's a difference between extension and a change of status. So you can do both at the same time. What you cannot do is to apply for 2 change of status at the same time. You cannot apply for a change of status to 2 different status at the same time. But you can apply for an extension of your status and also a change of your status. You can do that at the same time. And in fact, under the current administration, it is advisable that you keep yourself in status by applying for a change of status before the expiration, by applying for an extension of status before your change of status application is approved. So that way, you are not out of status at any time. But is it possible? Yes, it is possible. Next question, please. I see that we are already past one. Can you please look at the last question for the day? Okay, you already did. Okay, thank you.
This is just a comment for one of the people that commented. So he's just commenting more on someone else's.
What is this? Yeah, don't do it. I'm a victim of bad advice. I left a PhD F1 and switched to asylum. I regret it now because asylum was denied. I'm now in limbo because I can't adjust status on any other ground. Okay, yeah, this person is just reinforcing my advice that it is not advisable. I will not do it. Yeah.
This is the lady that talked about the surrogacy earlier.
Okay, yeah. The eggs used for fertilization was biologically mined egg. Okay. If the egg is biologically yours, then when that child is born through surrogacy, you may need to do a DNA test to confirm that it is your egg. And then in that case, you have to do what is called consular report of birth. Consular report of birth. So if you are already a US citizen, if the egg is yours biologically, all you need is to provide documentary evidence of that, which only a DNA can do. So once you have a DNA, then you file consular report of birth at the US Embassy. Next question, please. Hello, sir. Thanks for the program, and may the Lord continue to increase your knowledge. Amen. I overstayed in and moved to Canada afterwards. I applied for a US visa after being a permanent resident holder in Canada, but was refused, saying I'm banned for overstaying and also for marriage fraud. My question is there anything to be done in order to come to the state? I'm now a citizen. Part 3. Can I transit in USA without any problem? Flight passing through USA. Okay. 3 questions in one. Yes, I will answer all 3. First and foremost, when you overstay, there are 3 implications. There are 3 immigration implications for overstay. In fact, 4 immigration implications for overstay. If you overstay for a period that is less than 180 days, that is a grace period. It will not affect you in your ability to come back to the US. It may affect your ability to get a visa because the embassy may say, oh, the last time you overstay and deny your visa. But remember, that one is a discretionary issue. It's not about being legal or not being legal, because even people who didn't overstay can still be denied a visa. Now, the second implication, if you overstay for a period of more than 180 days or more, but less than 1 year, if you step out of the US, you are barred from returning to the US for a period of 3 years. 3 years. The third implication, if you overstay for a period of 1 year or more, whenever you step out of the US, you are barred from returning to the US for a period of 10 years. 10 years. Now, the fourth implication, if you overstay for a period of 1 year or more, you left the US and you re-enter the US a second time illegally. Now, in that situation, you are barred permanently from getting a permanent resident in the United States. So the part 1 of the question, those are the 4 implications of overstays. Now, the second question relating to the 204C. Now, Section 204C of the immigration law says that no petition shall be approved if an alien has been accorded or has sought to be accorded a preference status as the spouse of a U.S. citizen or spouse of an alien lawfully admitted to permanent residence by reason of a marriage determined by the Attorney General to have been entered into for the purpose of evading immigration laws. Or B, the alien has attempted or conspired to enter into a marriage for the purpose of evading immigration laws. Now, as a student of English when we were in high school, one of the things we were taught between the word will or shall is that whenever shall is used, it means compulsory. So the language of the law in this particular section 204C is shall. No petition shall be approved. So the implication of a section 204C finding is that the US government, the Attorney General, has made a determination that you enter into a marriage solely for the purpose of getting green card. And because of that, there is no petition that is filed on your behalf that will ever be approved, at least until the law changes or except the Congress change the law. That is the implication of Section 204C. So because you are already outside the US, there is no petition that you can file that can bring you back to the US. If you file employment-based petitions, they will be denied. If you file a marriage-based petition, they will be denied. So that is the language of the law. No petition shall be approved. Unfortunately, that is the situation with you regarding the implication of Section 204C. Please go to the third part of the question. Now, can I transit in USA without any problem, flight passing through? As a Canadian citizen, yes, you can transit. But remember, transition is also part of non-immigrant, discretionary non-immigrant power. So, even though you are transitioning, the CBP officer may decide that you are not allowed into the United States. They can limit you to the airport. They can limit you to the airport and not allow you to enter the US. But yes, you can transition, but they can limit you to the airport. Next question, please. Yes, my US citizen wife filed for me, my daughter and son in 2023. I got my green card, same with my daughter in 2024. But my son's I-130 has not been approved. He's in Nigeria, is now 17. What can I do? Well, the process of applying for somebody who is outside the country is different from applying for somebody who is inside the country. So because your son is outside the US, so you have to wait for USCIS to approve it, and then they will send the approval to the National Visa Center. They will process it. They will ask your son to provide fingerprinting after you pay the immigrant visa fee. And then once they finish processing it, they will send you an email confirming that your case is documentarily qualified, and then wait for an interview date at the US Embassy in Nigeria. Now, the issue here, did this person mention Nigeria? Or maybe that's my imagination. Yeah, okay. Yeah, the issue here in this particular case is that, one, for as long as the marriage that created the stepchild relationship occurred before the age of 18, and in this case, you said that your son is still 17, so there is really no problem. They will still approve it irrespective of your son's age. Even if your son age out. This is one of those situations where Child Status Protection Act comes to play, and your child will be protected, your son will be protected. So there is no worry regarding to whether she will be able to get the green card. For as long as you remain married and everything is okay, there is no problem. Your son will still be here. Again, this fact didn't tell us how long this your son's petition has been pending. So check the processing time. If it is outside the processing time, you might want to do a service request. If the service request does not work, tell your wife, you and your wife should go and see the congressman in your district for intervention so that they can expedite it. But there is really no cause for alarm as far as the age is concerned. There is no question of aging out in this particular type of case. The next question, please. We got married on February 26th. Can I file for I-130 now or withdraw the asylum?
No, this is like a follow-up to this one right here.
Is it the person that was on F1?
The fiance. My fiance and I met in 2024. Or maybe we haven't said that one yet, right? I think we had skipped it. Sorry.
Okay.
That's a no.
Hello, Dr. Asekun. My fiance and I met in November 2024. At this time, she already filed and had an interview with the immigration for asylum status. She's currently awaiting immigration. Can you scroll down to the next one? Okay, we got married on February 26th. Can I file for I-1 or withdraw the asylum? No. Don't withdraw the asylum. File the I-130 because I-130 is not going to keep him in status. If you are a U.S. citizen, file the I-130, let him file I-485 along with it. So when they invite you for interview, that is when you should withdraw the asylum. The next question, please.
Let me just make sure that I'm not skipping it. This one? No, here, we already answered that one. Okay, so this one.
Okay. Is there any cause for panic because I check my status every day on my case type I-751, but my USCIS status remains since 2023? That case was updated to show fingerprinting were taken. Move on, is there?
I think that's it. I think he's still within the normal extension period.
Yeah, like I said, if it's still within the normal processing time, there is no cause for alarm. Even if they didn't update it, there's nothing you can do at this time. It is only when they are outside the processing time, that's when you can do a service request or even seek congressional intervention. But if it is still within processing time, there's really nothing you can do other than to wait. Please move on to the next question.
Okay, so that's another follow-up to
I'm a citizen filing for my fiancé.
this is the person right here.
Okay, if it is that same person, you cannot even file the I-130 as a fiancé. You have to get married first. And then file the I-130, and then your fiancé can submit the I-485. And when you are invited for interview, then you withdraw the asylum. Next question, please. The U.S. citizen is petitioning for a sibling. The sibling is in the U.S. but is now out of status. Okay, I remember that question, but I think I answered it too. So, like I said, it's only immediate family of a U.S. citizen that can adjust when they are out of status. The next question. God bless you. When a 14-year-old qualify under INA 320 and have American passport, can N600 or L600K be filed while the child is attending school abroad? If you have American passport, you don't need any of this. You can attend school abroad. You can go 20 years, 30 years. It doesn't change anything. You are a citizen. So that one is not something that is necessary. The only thing is if your American passport expires while you are abroad, go to the U.S. Embassy abroad to renew it. Dr. Lu, as a green card holder, if you file an I-130 for your children while married to a U.S. citizen, but divorced soon after the petition was submitted, does that affect the I-130 application? Well, it depends on a number of factors. If you can establish that your children have an independent relationship with the U.S. citizen spouse or former spouse now, then the I-130 will be okay. They will still approve it. But if they don't have an independent relationship, if their relationship is entirely based on your own marriage to that now your ex-spouse, then the I-130 is going to be denied. Even if it is not denied, if your children are not here, they will bring them, they will deny it at the embassy. If they are here, when you go for adjustment interview, they will also deny because they will ask the petitioner to show up. But if they have independent relationship with your ex can still go through the entire process and the petition will still be approved, irrespective of your divorce. Next question, please. Hello, Dr. Asekun. Much appreciation to you and your team and your solid team for this act of service you are providing to us all. I came into this thank you. I came into this country with an F1 in 2016, but I didn't attend. Please move to part 2. I didn't attend school due to financial reasons and went out of status. I filed for asylum in 2017 before clocking 1 year in the state. I immediately enrolled back to school after receiving my EAD and social security number and graduated in 2022. I got married to my wife, U.S. citizen, in 2022 and filed for adjustment of status under marriage. Thankfully, we now have 2 kids together. I got my 2-year green card in 2023 and immediately withdrew my pending asylum application. My green card will expire in a few months and I have filed Form I-751 and received a 48-month extension. What if I divorce now?
No.
Is that
Part 5.
okay? Should I be worried about traveling out of the country with my spouse in this current administration?
And this is the last question.
Can I travel to Nigeria after becoming a U.S. citizen, given that I have previously filed for asylum but withdrew the pending application? Okay. Go back to that part 5. I'm trying to see should I be worried about traveling out of the country with my spouse? No, you have nothing to worry. You have nothing to worry about. Even if you divorce, there's nothing to worry about because there is, based on this fact, and I like the way that this person provided a lot of information. At least it helps to be able to guide you accordingly. Based on this fact, the fact that you have 2 biological children is more than enough evidence that this is not a fraudulent marriage. One thing must be very clear. The law does not say that a marriage must be viable. What the law says is that at the time you enter into the marriage, it must be in good faith. You cannot enter into a marriage just for the purpose of getting green card and then later you divorce this person. That would be problematic. Even if they found out that the marriage was just for the green card, that is what Section 204C forbid. So it is very, very important that in this particular case, you have overwhelming evidence that this is a legitimate marriage. You have two children already from the marriage, so there's really nothing to worry about. You can actually travel, irrespective of the situation with the current administration. However, there is an important thing that you raised regarding the asylum and traveling to Nigeria. Can you travel to Nigeria when you become a U.S. citizen? Yes. Even before you become a US citizen, you can travel to Nigeria for as long as you have withdrawn your asylum application, because there is something called change country condition. I don't know the reason for your asylum, but there are always change country condition. What if the whatever is causing you fear, if that fear has been removed, if the fear is no longer there, definitely you can go back there. So there is change country conditions. Yes, when you become a citizen, you can go back to Nigeria without any problem. Next question, please.
Have you answered this one?
I filed for my son while I was a green card holder. However, in 20, I became a US citizen and I contacted. No, I don't think we have answered this. Can you check the one before that?
Yeah, you answered this one. Or you did. Okay.
Remember, this one is a 5-part, so we
Yes.
may have skipped some in order to get to
Right.
the other
Okay,
part.
so this will be the next one.
Okay, so the one on top, is that the first part?
Is the second part
Yeah, so
from the 6-part question.
so did they follow part 1 and 2? Did they follow each other? If not, we
Yeah,
may have
1 and
skipped
2,
a
yes.
question.
1 and 2 follow each other.
Okay, yeah, then good. Yeah, that should be
And
the
then
next
this is
question.
3. But this is in between them.
Okay. I'm on F1 status, Dr. Asekun. Can I fly within the US during my spring break for holiday? Oh, yes. Oh, yes. Just make sure you get a state ID or a driver's license. And one thing I know, there is no state in the US today that is not giving real ID compliant IDs. Yeah, you can travel within the state conveniently. There's no problem. But just try to get state ID or driver's license. So that way you don't even need to carry your passport. You just travel with your ID card and your boarding pass.
And make sure he doesn't join any protests.
No, I've said that at the beginning, and I'm going to repeat it at the end of the program. If you are still a student, don't participate in any protest. Don't participate in any protest. Don't post any anti-government post on social media. All those things are affecting people. Hundreds of student visas have been revoked in the last 1 week. Hundreds of student visas have been revoked. So if you are on F1, don't participate, leave every protest for US citizens. Even though America is a country of freedom, but at this time, our freedom is being tampered with. So don't participate, please. The next question. Can I file an EB petition and when it is approved, join the military based on the approval, or have to get the green card first? Of course, you have to have green card before you can be admitted into the military. In the past, a long time ago, they used to admit people who are students onto the military, and then they will process their citizenship and everything. But they realized that people were just using the military to get citizenship. Because what people were doing is that as soon as they get their citizenship, then they de-enroll. In fact, I've seen people who offer to pay all the benefit that they give them, they offer to refund it. But of course, you can't refund the citizenship. So they were just getting citizenship, and then the US government realized that they were being used. So they stopped admitting non-citizens. So for you to join the military, you need to have green card first. The next question, please. Okay, in 2021, I filed for my son while I was a green card holder. However, in 2022, I became a US citizen and I contacted USCIS to update my status. The case was documentarily qualified on February 12, 2024, but we haven't, please move it forward a bit. We haven't received any update since then. Thank you. Well, this person, from this fact, I think you have made some mistake. If your case is already with NVC, and you updated your status with USCIS, the embassy may not have that information and the NVC may not have the information also. So what you should do is to contact the NVC, National Visa Center, to update your status with them. Let them know that you are already a US citizen. Secondly, this question does not tell us how old your son is, because if your son is still under 21 and you are already a US citizen, that will put your son's case in the priority list, because you fall into immediate family of a US citizen. Remember, the benefit that immediate family of a US citizen have, immediate family of permanent resident don't have the same benefit. So it is important to update the appropriate authority. In this case, will be the National Visa Center and the US Embassy. Your file has already been sent to the National Visa Center by USCIS. So updating USCIS at this time may not help your situation. The next question. Sorry about the earlier question. A friend of mine came into the US legally, but is now out of status. He's a brother.
This is the sibling.
Okay, he has a brother who is a US citizen. Can the brother petition I-130 for him? Yes, the brother can petition I-130 for him, but that will not keep him in status, because right now, the sibling of a US citizen, the waiting time for that category is about 16 years. So the petition will not keep him in status, but at the same time, the journey of 1,000 miles begins with a step. We don't know what will happen in the future. The petition may become useful in the future. We don't know, but that petition will not keep him in status, but the brother can submit it. Next question, please.
This is the part.
Yeah, we have answered those ones.
We already answered that too, and this
Yes.
one too. Okay. That was the last one. Part 6.
This one.
Yeah, we already answered.
So I already answered. Okay, so we are going to stop here for today. We spent almost going to 2 hours now. However, before we round up, I want to say, as I always say at the beginning of every podcast, we hope to continue again next week. But I want to say, if you are not yet a citizen, please mind what you post on social media. The internet does not forget. The internet does not forgive. Even if you go back to delete it, they have a way of retrieving those things. Some people may have taken a screenshot. The internet does not forget and the internet does not forgive. Be mindful of what you post. Please be mindful. This current administration, it does not matter your status, whether you are a US citizen, you are a permanent resident, you are a non-immigrant, it does not matter. They are scouting the internet. They are scouting the social media. They are looking for information about people who are criticizing them. We are actually right now running a system that is slightly short of dictatorship. They are scanning the internet. They are scouting, looking for things to use against people. If you are not yet a US citizen, please do not participate in any of these things. Do not participate in any protest. If fellow students call you to let you go and protest, even if you have lied to them that you are a citizen, find a way to avoid getting involved. If they are signing any petition, make sure your name is not on that petition. Don't do any act of heroism. Don't do anything that will lead you into trouble. Right now, they are revoking visas for students, people who are legitimately in schools. Their student visas are being revoked. Please beware. Sometimes we make one silly mistake that will be costly. That is why we are providing all this information. Don't be an activist right now. This is not the time. You are not yet a citizen. Don't be one. Even US citizens are sometimes being arrested mistakenly now. How much more people who are not citizens? Please, and as I said before, the court of appeal, the Fifth Circuit Court of Appeal, they have said that the government have a right even to search the telephone or bags of US citizens entering the US at the airport, at the port of entry. So if the court is saying that they have the government to search the phone of a US citizen, how much more those who are not US citizens? So be mindful of what you put on your phone. Be mindful of what you post on social media. Be mindful on conversations that you have. You may find yourself in a situation where your phone is collected and copied. And by the time you realize what is going on, it may be too late. Please avoid all these things so that you make it easy for us to defend you if there is a legitimate problem. I'm saying all these things because we are facing a lot of challenges in court nowadays. We see they arrest people, they take their phone, they copy it, and then they come back and use the information they obtain in those phones to argue that this person should not be given bond, to argue that this person should be detained, to argue that this person is a danger to the community, to argue that this person has a form of link to terrorism. So all these things we are facing in court right now, please make it easy on yourself. Make it easy for us to defend you as well. Until next week, we hope to continue again. This is Dr. Olu Asekun. Have a blessed day and remember to join us on other social media. We are on what?
Instagram,
We are on Instagram, TikTok. What else?
so it's
YouTube.
YouTube.
Aha. So all of these things we are providing information that will guide people. So always remember, and remember to tell other people too to benefit from it. If you are not able to join live, you can go back to watch these things. They are being recorded and posted on our YouTube channel. Thank you again for joining us. I remain yours truly, Dr. Olu Asekun. See you again.